Hello, I'm Sarah Abdulmatolib, and I'm the symposium editor of the Texas A&M Law Review. I'm joined today by fellow Law Review staffer Mark Gannon, Professor Riley, the Associate Director of the Aggie Dispute Resolution Program, and we're also honored to be joined by Professor Carrie Menkel-Meadow, who is the Distinguished and Chancellor's Professor of Law at UC Irvine and is one of the preeminent scholars and founders of the dispute resolution field. On March 4th, 2022, the Law Review and the ADR program will be co-hosting a symposium entitled The Renaissance Woman of Dispute Resolution, Carrie Menkel-Meadow's Contributions to New Directions in Feminism, Ethics, and ADR. We're excited to be able to have this conversation today with Professor Menkel-Meadow herself as a bit of a preview to what we are sure will be an amazing event this spring. So thank you so much, Professor Menkel-Meadow, for being here.
This is just so much fun to listen to your answers on this, I just have to say. So my question is, we've heard a lot in the last few months about diversity, equity, and inclusion. What role should law schools be playing in this? Both, I guess, with students and in the larger community and in the larger world.
Oh, you want me to solve that whole problem? I just have to say, from my vantage point of 40-something years in legal education, it's not popular to say this right now, but I actually think we've made enormous strides. I mean, really. I was not the very first generation as a woman professor, but 1.5, meaning that the first women law professors were 6 or 7 years older than me. So when I came in, there were almost no women. I went to UCLA as my first formal teaching job, in part because I was the 4th woman on the faculty there, not the first. So one thing I want to say is critical mass. That comes from my work on the sociology of the professions. The best way to enhance diversity, equity, and inclusion is not to just have a representative, an African-American, and Native American, Latina. Sorry, I say Latina, Latino. We don't want to get into the Latinx thing, but I spent a lot of time in Spanish-speaking countries, and they don't all recognize Latinx yet. So I'm still doing Latino and Latina. We can discuss that in March. But the key thing is, for diversity, equity, and inclusion is it's not just about the people's faces, it's the ideas that they bring to the table. And we know from the research that was done decades ago by Rosabeth Cantor, Peter, you should know this as a trainer, in organizational development, it's not enough to just have a single representative of some minority or underrepresented group at the table. In order for ideas to be heard and to be absorbed into an organization, we need a critical mass of whatever that diversity is. So it could be gender, it could be race, it could be religion, it could be politics. Now, here's another controversial point. This is something I bet you have less trouble with in Texas than we do in my school. I think one of the biggest issues that we're facing now in a lot of academics is lack of diversity of political view. So in my very politically correct school at the University of California, and I don't just mean Irvine, I mean the University of California, which is now highly diverse in the student body, less so in the faculty, but getting there. We have a serious crisis of cancel culture and political correctness. So DEI, diversity, equity, and inclusion, which has become this acronym, every committee that gets formed now here with big bureaucracy here at the University of California, what is the DEI? Who are the representatives of DEI? What are we doing in DEI for teaching? We have just at UCI developed a required course. No one's teaching it yet. We're developing it. There will be a required course on race and indigeneity and the law that every student will have to take, which is very important. And I was all for it. I voted for it. I think it's important to do that. But I also have experienced, even as a very progressive teacher at this school, that students who have a slightly unpopular view about anything, including this topic, but anything, are afraid to open their mouths. So this part of me is old school. I am not a free speech absolutist. I don't think anything goes with speech, But if diversity means anything, we want diverse bodies, diverse embodiments of different kinds of people. Why? Because we believe that people of diverse backgrounds will have different views, and that the sum of our knowledge as human beings will be better if we have diverse views in the room. So I think law schools have done it. I was a huge proponent of affirmative action when it was okay to say that word. I fear that in the current term or next term, the Supreme Court will probably foreclose that. You guys in Texas were at the forefront of the last set of battles on that issue. I think efforts to create past justices should be lawful. So I hope the Supreme Court doesn't do what I think it's going to do and strike down the remaining legal justifications for it. We're getting close to Sandra Day O'Connor's, 25 years, hence we won't need this. So I believe that law schools in particular have been working on diversifying their student body and certainly diversifying our faculties. All of our hires this year were people of color at Irvine on the faculty in the law school. So we are working on that. And I think law schools have generally been doing a decent, if not perfect job as compared to other parts of education. And all I would say, as I've said at the beginning of this, for me, the key is not just a single representative of any group that's regarded as underrepresented in the room. For people to be heard, there has to be a critical mass. And so I'll just say, from my own experience as a woman, when women first came into legal education, we have a story, and Hillary Clinton tells a story too. All of us have the experience first few generations is we would say something in a classroom or in a seminar or in a faculty meeting, and essentially we'd be ignored. And 10 minutes later, some guy would say the same thing. And the chair of the meeting would say, "Oh, great point, Professor Riley." And Professor Menkel-Meadow would say, "Didn't I just say that?" And as some of you may know, there have been vast amounts of studies to show that, the devaluation of the woman's voice. There have now been some incredible studies to show another side of that, which is that females are interrupted more often. And some studies done by Tanya Jacoby at Northwestern show that the women on the Supreme Court, there's now 3 of them. And there were altogether 5, Sonia Sotomayor, Ruth Bader Ginsburg, Elena Kagan, now Amy Coney Barrett's going to happen to her too. They get interrupted more than the men do. And this has all been documented to statistical significance. So in their case, because with finally more than one of them on the court, they're still getting devalued. And so I just say that to say that diversity means diversity of view, and inclusion means more than just a couple of anything. If we're going to have an effect on the world, it's not just that 1 or 2 people become assimilated into what already is, but that we actually diversify what we think about things by having enough of them in the room so that their voices can be heard.
If I could just have a quick follow-up to that.
Sure.
It's sort of, in a way, you talked about your time at UCLA, and in a way, you had to kind of buck the system to do the scholarship that you were doing, especially at the beginning of your career. And I want to know if you could say something about, it had a happy result, right? You essentially helped found a field. But what can you say to especially newer scholars who are wrestling with this?
I love that question. That question, Peter, you should know, got asked of me for all the LLMs that I supervised at Georgetown over the years, people that wanted to become professors. How do I make a life? And I sound like a broken record because I've said it so many times, and you've heard it from many people. If you have a passion for a subject, stick with it. And I just want to tell anyone who's listening or watches this, I'll tell the story in March. When I wrote my first negotiation article, which is now in the 1984 volume of the UCLA Law Review, my first big article on negotiation, the first time I sent it out, it was rejected everywhere. And I papered my office like F. Scott Fitzgerald and all the great writers, with all the rejections. And it was easy for me to do because 1 year later, this is a wonderful story, you guys, for the Law Review. 1 year later, I was teaching with the draft of this article, which was at the moment that it was in my hands, still rejected everywhere. And bless her heart, I owe my whole career to a woman named Sharon Nolfi, who was then a 2L at UCLA, taking my negotiation course, and had just been elected editor-in-chief of the Law Review, a woman. a former teacher, a woman who came to law school later in life. And she said, I love this article. Can we have it? UCLA. Now, the interesting thing was when I was a young professor, I know I'm hogging up a lot of time here. When I was a young professor, we were told, don't ever publish in the house organ, right? You've got to show that your work is appreciated outside. So I hadn't submitted it to UCLA. And when she said, can I have it? I said, bless you. You can have it. And the rest is history because it got published. And then 8 months later, or however, I think even before it came out, I won the first Center for Public Resources award for scholarship in ADR. It was in 1983, 84. I think the award, whatever. It came out just as the article came out. Can you imagine what this did to my parents? CPR was in New York, big fancy ceremony in the University Club, which, since we're talking about diversity and inclusion in here, University Club off Fifth Avenue, New York City, excluded women for sure, and certainly Jews for a long time. I'm half Jewish by birth. My father was Catholic, my mother was Jewish. So and we were raised ethical culture. I can go into that in March. But me as a person wouldn't have been allowed in the University Club, and I wasn't when I was growing up. So imagine I'm now just about, what was I, 32 years old or something, and I get this big award. So bless CPR, which was an organization of corporate general counsels of the Fortune 500 companies that recognized in this article about problem-solving negotiation that not everything had to be solved by litigation. So I tell you that I was very lucky. But the main thing I want to tell anybody is persistence. And as Peter suggested, I was incredibly lucky because I had gone from being a clinical professor at Penn to UCLA. Penn would never have acknowledged at that time my negotiation article. There were only maybe 3 cases cited in the footnotes. There were 400 footnotes or something, but they were mostly social science and other things outside of law. And at that time, UCLA was a school that really represented inclusion and diversity of ideas. So my colleagues, when they saw I was getting rejected, they just kept pushing to make it better. I have to say one other thing to both to junior lawyers and junior scholars. There was a great culture at UCLA that whenever a young person wrote a new person, wouldn't necessarily be a young person, a new person on the faculty wrote an article, there was a culture in which almost everyone else on the faculty read it. So here's another tip for everybody. I used to name my footnotes. This is the Peter Riley footnote, because when Peter read my draft, he said, Carrie, I don't agree with that point that you've made in the text. And so I'd have to stop and think, what is Peter's criticism? And sometimes it would be in the text and I would take it full on. But other times I would say, well, it's not really central, but I have to answer it. And so every one of my colleagues at UCLA read the first drafts of my first 3 articles, and then I would name them. This was the Peter footnote, this is the Sarah footnote, this is the Mark footnote. They've raised these questions and I'm going to answer them. I'm not going to ignore them. I'm going to take it on and answer it. And I think that was respected in the culture of UCLA at the time. And I remember seeing my preliminary tenure report written by a fairly distinguished scholar at UCLA who said, I think this thing is terrific. I have no idea how the rest of the world is going to respond to this. And so we'll see when we get the outside letters, because we at UCLA have to make our own judgments, but we also want to be sure that this person's doing something that's valued in the outside world. That was the risky part, because I actually felt pretty supported by my colleagues at UCLA, but then it floated out in the world. And at that point, only Roger Fisher at Harvard was actually teaching negotiation. And they didn't want to ask him, you guys, if you're taking any ADR, you're going to laugh. Getting to yes, my Bible, my Quran, my Torah, whatever you want to call it, my Bible, getting to yes, was not regarded as a scholarly work. So the UCLA faculty didn't care what Roger Fisher thought. I mean, he was a very distinguished Harvard professor, but they didn't think he was a scholar. So they sent it to contract scholars and some law and society scholars. And I'm very proud, I will say this, that it was a very interdisciplinary piece. And I'm proud of my faculty and proud of whoever, not known to me, all those outside letters were, because it's hard creating a new field. And fortunately, they rounded up enough people value it. And so I can say that after a kind of painful start of nothing but rejection letters, ever since 1985, I got tenure in 1984, I feel like I've had a very privileged, lucky, and charmed career. And if I might, I just have to add one other feminist point here, Sarah. What I have just said is classic, female. You'll study this if you take the right classes. Psychologists have documented that good things happen to women. They say, oh boy, was I lucky. Good things happen to men. I really deserve that. Bad things happen to women and they say, oh my goodness, I really messed up. I did a terrible thing. Bad things happen to men. It's somebody else's fault out there. So that's attribution theory. And I understand it intellectually and I do it all the time. I still, I just want to say, I thank you to my colleagues who were so nice to me. They weren't all so nice to me. Most of them were, and I got tenure, but there were a bunch of people who thought what I was doing was crazy stuff. And I will say this, and that it didn't belong in a law school because my initial article had no cases in it. So my advice to everyone is look for your passion, really. And that's both for practice and for anybody who's writing anything. Stick with it. You will get rejection notices. You will get told that what you're doing isn't what we want. And if it's what you really want and you see the value in it, just look for the people who do see the value in it and get your support for that.
That's awesome. Professor
Yes.
Riley, did you have anything you wanted to follow up on?
No, I loved hearing that.
Mm-hmm. Yeah, I love just hearing those insights and the details about, the early part of your career, especially. And thank you so much for the advice and for the time that you've taken to talk with us today. We're just really so honored to be able to, continue to examine your work. And this conversation today has really gotten me even more excited for the upcoming symposium. So just thank you so much again, Professor Menkel-Meadow, and hope to see you in March in person, hopefully.
Yeah, let's hope. Thank you guys so much, really. It's just wonderful what you're doing, and I truly appreciate it.